Hey everybody, welcome back. Today's video is going to be a little bit more narrow in terms of demographic that's for. It's specifically aimed at California voters, though if you are from outside of California or not a voter, you are more than welcome to stick around. I'm going to be talking about Proposition 22, which you might have probably heard of by now. It's been in the news, it's very contentious. Lots of people have lots of opinions on it, and I want to help you understand why this is such a big deal. Hopefully this video will accomplish that. This proposition was brought to the ballot by Uber, Lyft, Postmates, DoorDash, and Instacart. These companies would like to have you believe that they're really in it to fight for the drivers, for their right to not be full employees, but since when have companies ever fought for their workers to have more rights? This proposed law is just the latest in a battle over state policy that might regulate these companies, following in the path well established by gun and tobacco industries. Luckily, this is probably a one last desperate attempt to foil California before they're forced to give in and give their workers what they're due. Unluckily, these companies know that they have a lot to lose and have put a lot of money into staving that off. In fact, this has become the most expensive ballot campaign in California history. Early voting has already started, and over 6 million ballots have been cast, which is about 27% of the eligible voters in the state. So in the interest of time and in retaining attention, I've broken this topic into 3 videos. The proposition itself, the battle to get here and the underhanded tactics that these companies have used, and then the very business of buying an election. So first, let's break down what exactly Proposition 22 is. So the law that currently exists is Assembly Bill 5, which was signed into law last year. It's the result of numerous court cases since the 1970s that have attempted to regulate what is called the gig economy. AB 5 is great in that it creates an easy test to distinguish independent contractors from employees, and that can save the state millions of dollars. App-based companies, however, hate AB 5. We'll go into details later about what they tried to do about it, but for now, the important thing to note is that Proposition 22 would carve an exemption for these companies from this law and other similar laws, such that they would be completely deregulated. So the proposed law begins by making its argument that lots of Californians are choosing to work as independent contractors and that the business benefits from these services. It's important that they emphasize that these are parents who want to work while their kids are in school, or students trying to make some extra cash in between classes, to create the idea that this is just some people working for a few hours a week. They don't need to be full employees. Of course, that's not actually what's going on here, but we'll get to that. So the proposition continues to say that AB 5 threatens this flexibility, and protecting the ability of Californians to work as an independent contractor throughout the state is necessary. Of course, AB 5 doesn't get rid of independent contractors, it just makes it so that the companies have to prove that that's what they are, and these companies fail to pass that test. Article 1 continues to summarize the new benefits and protections that are not available under current law, and promises all of these things. Now, they may sound nice when put like that. The proposition does say that its purpose is to protect the basic legal right of Californians to choose to work as independent contractors with rideshare and delivery network companies throughout the state. But what it doesn't say is the benefits that these workers are actually entitled to. These are the benefits that every employee in California is eligible for. So not only does the proposition pale in comparison to what these drivers are actually owed for their work, what it does promise isn't even as good as it sounds at first. So let's go piece by piece through the text and see what it says, shall we? Article 2 counters that test I talked about earlier and creates its own rules for what counts as independent contractors. AB 5 declares that a company has to prove three things: that the worker is free from the employee's control, that the work is outside the usual course of the business, and that the worker is engaged in an independent trade, occupation, or business. These network companies can't pass these tests because A, the companies control which drivers receive which ride requests and how much they can charge for the ride. B, the work that the drivers perform is core to the business. And C, drivers aren't engaged in their own business, they work for the company. So what Proposition 22 claims instead is that an app-based driver is an independent contractor because the network doesn't give them specific dates, times of day, or minimum number of hours to be logged in. They don't require them to accept any specific service or request, doesn't restrict them from working for other companies, and doesn't restrict them from working for other occupations. By changing the requirements, the company makes sure that the employee relationship is defined by the terms of the contract and the provisions of the ballot initiative alone, and that legislators, state and local agencies, and the courts have no power to determine if the workers are entitled to any protections. The first promise is the earnings guarantee. They create a net earnings floor based on 120% of minimum wage, and if a driver makes less than that, then they'll be compensated the difference. The earnings period will be at least every 2 weeks, and the companies can't take any money out of their tips, and there will be a per mile compensation of 30 cents per mile. If a driver makes more than that floor, they won't be given anything extra. What should be emphasized is that these earnings are calculated and paid using engaged time, or engaged miles, which only includes the time spent after a driver accepts and then completes a request, and not any other time spent waiting while logged in, while technically working for the company. According to studies done by the industry, that's about 37% of the time that a driver spends that won't be compensated. And as a result, drivers would have to have longer shifts in order to make up for the loss. Of course, there's no provision for overtime either. Under state law, employees should get 50% of minimum wage if they work more than 8 hours a day or more than 40 hours a week. And the standard IRS mileage reimbursement is 57.5 cents per mile, and it doesn't rely on engaged miles. Moreover, California law requires that an employer reimburse a worker for all work-related expenses. Remember, in order to even work for these companies, a worker has to have a phone plan and a phone that'll give them the coverage that they can work through the app, and a vehicle and the ability to maintain that vehicle. And as we'll get into later, right now, they need PPE too. Also, as much as these companies would like to have you believe that most of their workers are just students or moms or trying to make some extra cash, a San Francisco study that was done on on-demand workers by UC Santa Cruz this May found that more than half of them use these companies as their primary source of income. So they're working way more than a few hours per week. Other standard wage and hour protections that the companies would be exempted from includes protected meal breaks, paid rest breaks, protections from unlawful withholding of wages, 1 day of rest every 7 days, and immediate payment of wages on discharge or resignation. Next comes healthcare, or healthcare subsidies. Some workers will be qualified to access subsidies to buy health insurance from Covered California. So it'll be a quarterly healthcare subsidy. For drivers who work more than 25 hours a week, they'll get 100% the average ACA contribution. And for drivers who work 15 to 25 hours a week, they'll get 50%. To qualify for the subsidy, the driver has to be enrolled in a qualifying health plan, and they have to have health insurance membership or ID cards, evidence of the health plan, or some other documents necessary. They can get subsidies from more than one company, and this section is void if California or the US implements universal health care or a similar program that covers the recipients of subsidies, which is So very thoughtful of them. Buried in the definitions, though, is a clarification that the average ACA contribution means 82% of the average covered California premium for the lowest cost healthcare plan on the insurance exchange. And the hours worked to qualify would come from engaged time, which means that to get that 82% subsidy, a driver would have to work more than 39 hours per week. And a qualifying health plan is one where the driver is the subscriber, not sponsored by an employer, not Medicare, not Medicaid. Next is loss and liability protection. They'll provide occupational accident insurance to cover medical expenses and lost income resulting from injuries suffered on the job, a coverage of up to $1 million, and disability payments of 66% of the average weekly earnings from the last 28 days for 104 weeks following the injury. There will also be accidental death insurance for injuries while the driver is online, but not if the driver is online but not engaged, if engaged with one or more other platforms, or doing personal activities. Automobile liability insurance is also provided of at least $1 million if it's not covered by other policies, but that only extends to third-party injuries, not the driver's injury or damaged vehicle. Suspiciously, there's no mention of whether that insurance will be offered on a no-fault basis, and without that detail, it's much easier for the insurance carrier to deny coverage if they can show that the worker was even partially at fault or in any way engaged in personal activities. It's the little details, or lack thereof. California law, of course, requires compensation coverage for any injury on the job on a no-fault basis, and in addition, the wording is specifically that a company should carry, provide, or otherwise make available the insurance coverage options. A vague phrasing that could leave workers offered coverage options that they have to pay out of pocket. Disability payments are limited here, as current law gives disabled workers benefits for life, not capped at 104 weeks, and no cap on medical expenses, as well as vocational retraining for some workers. If you think I'm looking too closely at syntax here to make my argument, and that if a worker thought they weren't getting the benefits they needed, they could just appeal the decision, well, the proposition takes jurisdiction away from the Workers' Compensation Appeal Board. So if there is a dispute, the worker has to take it up to the Superior Court and would need to shoulder easily thousands of dollars in expenses. The next couple benefits I want to talk about don't even have a counter in Article 4. They're just denied entirely. One is paid leave. Nearly 18 million employees in California pay state disability insurance taxes, which provides access to paid family leave. The California Family Rights Act provides income protection as well, so that if a worker does need to take a leave for any reason, and with a pandemic there are more than enough reasons why a worker would be called away, they can know that they'll have a job when they come back. Employers are also required to offer paid sick days, something of utmost importance right now. In fact, major cities in California have extended paid sick leave, and essential food sector workers, specifically including app-based food delivery workers, have access to 80 hours of sick leave during the pandemic, but under Proposition 22, these essential workers would be denied such a thing. The other missing benefit is unemployment insurance, which is also extremely important as COVID continues. Workers are losing their job through no fault of their own, and the unemployment insurance system in California is meant as a safety net for them. Of course, Proposition 22 has no provision for this, because why would companies care about their workers when they're not making money for them? So that's all for the benefits. Next come the protections offered. Article 5 is about anti-discrimination protections. Unless there's an occupational qualification or a safety need, it is unlawful to refuse a contract, terminate or deactivate a worker due to discrimination. There's sexual harassment prevention. A policy has to be available on the website, which identifies behaviors that count as sexual harassment and indicate that the company and the law prohibits this. There has to be a process established to confidentially submit complaints, followed by an impartial and timely investigation and actions based on info collected from that. They have to be able to submit complaints electronically, and no one should be retaliated against for a good faith complaint. and employees have to review this company's policy and confirm agreement when they're hired. Now, anti-discrimination protections is not something new that Proposition 22 is proposing. It already exists under California law. This version of the proposition, actually, is a likely unenforceable imitation of those provisions. Most notable is the omission of protection based on immigration status. The same San Francisco study I mentioned earlier found that more than half of the workers are immigrants, yet there's no protections for them. And while the initiative promises other protections, it doesn't actually have any effective mechanism for enforcing those protections beyond a vague mention of procedures. The sexual harassment protection is particularly vague, as an undefined policy has to be published on the website and a process to submit complaints, which just need to be reviewed with an electronic confirmation. There's protection against sexual harassment claims, but no other claims. Also, there's a broad occupational qualification defense and a public or app-based driver safety need defense that could justify the company's actions, unlike the very narrow defense present under California law. See all of the loopholes that have been put in to prevent them from ever being held accountable for anything? Next is also something that these companies are already mandated to do, which is criminal background checks. They would have an initial local and national criminal background check prior to starting work, and no consent is needed for further monitoring. There's also a list of crimes, felonies, and hate crimes which may lead to suspension of the driver. The only concession made to occupational safety and health by the proposition is safety training, which includes collision avoidance and defensive driving techniques, identification of collision-causing elements, recognition and reporting of sexual assault and misconduct, food safety info for delivery drivers, and all of these must be provided either online, by video, or in person. There's a zero-tolerance policy for DUIs, also standard. And if a worker is logged in and driving for more than 12 hours in a 24-hour period without logging off for an uninterrupted 6 hours, the driver won't be able to log in for another 6 hours. Also, impersonating a driver is a misdemeanor. This gets rid of the requirements for an injury and illness prevention program, a log of work-related injuries and illnesses, and the need to assess, address, or prevent workplace violence, even though drivers and chauffeurs are frequently targets of workplace violence. And the most relevant absence right now is the silence on issues of assessing the need for PPE. A safety training course is already mandated by law. And anyways, it's an inadequate substitute for all of the other protections that Cal-OSHA offers. The company will be entirely in charge of what safety and health protections they give, and Cal-OSHA will have no jurisdiction to investigate violations or assess penalties. With that, that's the last of the benefits. And did you notice what's missing? That's right, the bane of exploitive industries everywhere, the right to organize. The initiative went to lengths to establish that the only thing that determines workers' rights is what's written in their contract. But then it also erases the ability to organize and bargain collectively, something that is, of course, otherwise protected under federal law for all employees. And if California wanted to pass a statute that would allow for collective bargaining for workers not considered employees, something that they did recently for farm workers, they have to pass it by a 7/8 majority, a ridiculous provision that we'll be getting to momentarily. So the workers just have to hope that the company will deign to bestow them with the rights they deserve and the protections that they need. But I wouldn't hold my breath. After all, who expects companies to do anything but what they're designed to do, which is make as much money as possible by any means necessary? The most overbearing bit of the proposition comes in the next couple of articles. It creates a lock-in mechanism that would protect the law from any changes, despite democratic will. Article 9 specifies that a 7/8 vote would be needed to amend the legislature after it takes effect, an unprecedented supermajority rule. That's 10 members of the Assembly or 5 members of the Senate that could dissent and completely stop anything from changing. So, in practicality, there will always be enough votes to permanently prevent any amendments. Any vote taken on an amendment, even before the 7/8 requirement, must be printed and distributed for at least 12 days before passage. Putting a near month-long pause on any amendment increasing the chances that it won't meet legislative deadlines or that it will be overcome by lobbying campaigns. And even if an amendment manages to pass both of those obstacles, it has to be consistent with and further the purpose of the act. Any amendment that tries to change the status of drivers as independent contractors or change any of the requirements for establishing the status would therefore be considered inconsistent and couldn't be modified. And finally, there's a provision to make sure that nothing can be passed preemptively to regulate the companies, as nothing enacted after October 29th, 2019 that could be considered an amendment can be considered operative unless it also does all of the above, even before this initiative passes. Should this pass, it would effectively let a small number of corporate actors to literally write the laws that govern their conduct for the low price of $200 million. But don't worry, that's not all. See, the above provisions are hurdles to amending the initiative itself, but it goes further and applies the requirements to any legislation that would stop app-based drivers from performing their job or put unequal regulatory burden based on their classification. For example, putting these companies at a disadvantage compared to taxi companies. Or anything that authorizes an organization to represent the interests of drivers regarding contract, compensation, benefits, or working conditions. It would cleanly and efficiently strip the government of any power regarding the employment relationship with the company or worker organizing rules. And the final trick comes in Article 7. The initiative says that in light of the cross-jurisdictional nature of rideshare services and delivery services, and the plethora of overlapping, inconsistent, and contradictory local regulations, that the state must establish uniform standards. That's a wide variety of local standards that would be negated, specifically anything having to do with compensation or gratuities, scheduling, healthcare subsidies, or any other workplace stipend, subsidy, or benefit, licensing or insurance requirements, and protections for workers terminated by these companies. The effort that countless activists and millions of voters have put into passing historic sick leave protections would be permanently nullified, and the expanded paid sick leave that has been passed in response to the COVID pandemic wouldn't be enforceable either, nor would public health measures. This combination of lock-in mechanisms has never happened before. Some ballot initiatives have put some small restrictions on the abilities of the state or local policymakers, but nothing to this extent. There's also some small other details in the last article regarding what would happen if anything in the initiative is found invalid that I found of interest. If anything at all is found invalid, or as it's put, any portion, section, subdivision, paragraph, clause, sentence, phrase, word, or application of this chapter, it would have no effect on anything else. But for anything to be found invalid in the first place, they would have to fight an uphill battle. There's a section that specifies the legal defense that the initiative would get with the purpose of, and I quote, to ensure that the people's precious right of initiative cannot be improperly annulled by state politicians who refuse to defend the will of the voters. So the Attorney General has to appoint independent counsel to defend the act. The independent counsel has to affirm that they will faithfully and vigorously defend the act. The general fund has to pay any amount necessary to cover the costs of the independent counsel without regard to fiscal year. The most expensive campaign for a ballot measure in California history, and we get the chance to decide whether it's going to be worth their money. Every detail in this initiative is ridiculous and kind of insulting. It goes to such great lengths to make sure that the government can do absolutely nothing to control the companies, and to make sure that they only give their workers the bare minimum, though at least they've tried to dress it up a little. But I'm sure most of you aren't surprised by this. After all, that's what companies do, right? Their only goal is to make money. Why would they care about their workers if they're not being forced to? And while that's true, I kind of resent that we've gotten to the point where we're just used to this. Or that there are so many people who think, well, at least these people have a job. That at least Uber and Lyft and DoorDash and Instacart and Postmates are convenient. And surely it would be worse if they were gone. Because that's what the companies have threatened to do. They've said that if they have to pay their employees and treat them as employees, they wouldn't be able to do it at the cheap rates that they have now. And they might even have to leave. A threat that they would, of course, go through with. They've done it before in Texas. Uber alone hired 370 lobbyists in 44 states to shape the law. Anything to save money, even though they're not actually making a profit anyways, because the company model isn't actually sustainable. But workers deserve better. They deserve the dignity of these benefits and rights and protections, and since the companies won't give it to them willingly, it's on us to fight for it. This is in many ways a last desperate attempt, but if it passes, it'll be the death knell of labor laws across the country. It'll prove that money really can buy anything. The people who work for these companies deserve better, and it's in your hands right now to give that to them. I don't really care about your vote in the general election. We all know it doesn't matter if you're in California, but please make sure that you look at all of the propositions, and I hope I can count on you to vote no on Proposition 22. My sources will be in the description if you want to look further into all of this, which I highly recommend, and my next video will be out hopefully soon, though probably not before Election Day, since I'll be working the polls and not really have the opportunity. Thank you for watching this all the way through. I know it was a lot. If you enjoyed the video, please leave a like and subscribe to make sure that you don't miss the next one. Stay safe, stay healthy, and I'll see you next time. Peace.